Доброго дня.
Good afternoon, ladies and gentlemen. Ukraine Crisis Media Center continues its working day, and we greet everyone who joined us here and online. The topic of the next press briefing is law against whistleblowers. Why should the president veto it? So we give the floor to our speakers. Thank you very much for joining us here. We thank speakers who are here today and those who are online, our international speakers. On the 4th of February, the Verkhovna Rada of Ukraine adopted a law against whistleblowers. And recently, we have assessed it as positive, but the amendments that were introduced in the whole of the parliament and voted for by people's deputies, they practically annihilate all positive things that were envisaged in the concept of this draft law. The matter is, practically, this law became the instrument not to protect the whistleblowers better, but this is a strike against them. And during today's discussion, we are going to speak about this law and what should be done in order to correct the situation. Together with us today, we have international and Ukrainian experts and also a whistleblower who informed about corruption cases. So first, Oleg Polishchuk, he's whistleblower, ex-director on corruption prevention from Energoatom, Andrei Biletsky, administrative director of ACREC, also Anna Myers, executive director of Whistleblowing International Network. This is an international network of whistleblowers, and also Tom Devine, legal director of Government Accountability Project. So today we will start, and I'm Oleksandr Kalitenko, legal advisor of Transparency International Ukraine. We'll speak about the amendments that destroyed this positive idea of this draft law. So it is difficult to provide information for whistleblowers. You should be really courageous to do this. And those amendments, they make situation worse, and this is really dangerous. Now the whistleblower needs to open sources of information. They add the amendment to the law that he should know the sources from which he gets this information. He should be sure about these sources, and this is unprecedented for this law. It doesn't correspond to international standards and best practices, and it may lead to the fact that in order to get protection, he should uncover his sources. For example, he may provide information about colleagues who provided information, and this may and will lead to isolation of whistleblower at his workplace, and for him it will be really difficult to get any help in order to uncover this violation. So also about internal channels of provision of information, they added amendment that whistleblower should be able to confirm these facts, and the head to whom he provides this information by the internal channels, this whistleblower should be absolutely sure that his head is not involved in these violations. So this may violate the rights. For example, this may be a person who is responsible for prevention of corruption, and the law, until introduction of amendments, broadened the circle of people who may get this internal channels. Now they narrow these channels to the head of institution. If the whistleblower, for example, is a student, or he serves, or he is a subcontractor, and in previous version they had it, and now he should be the worker of this enterprise. And the law does not envisage what should be done if the head of the enterprise is involved in this violation, and what should be the channels in this case, internal channels. So this makes these channels, internal channels, inefficient, and the number of whistleblowers who will provide this information through these internal channels, this number will decrease. It may even be nullified. Also, the deputies questioned anonymous and regular channels of provision of information. Before, they had clear mentioning that these are the channels of anonymous provision information. Now they do not mention this. This creates some collision with other norms of the law, in which this anonymity of whistleblower, the possibility to provide information anonymously, is not present now. So those amendments that were introduced in the whole of the parliament, that were voted for by the parliament, they raised applause among the deputies. Because among the arguments that were provided in the course of discussion of these amendments, they mentioned that these people just provide information like they did during Stalin's repressive times, like in 1937. And this was the reaction of the deputies, and they voted for these very dangerous for whistleblowers amendments. This is really unfortunate, and I would like to give the floor to Oleg Polishchuk. He is a whistleblower, and he will share what obstacles in real life exist before they had such obstacles and such amendments that were introduced by the deputies. They may influence future whistleblowers. Thank you very much. Good afternoon. Thank you for this invitation. I believe that if this law started its work starting 1st January, I believe maybe I was at my workplace because I wouldn't provide information. I would not have possibility to provide this information about Energoatom leadership and National Agency for Corruption Prevention. It is really difficult to inform them. It is difficult to speak about your leadership. And this is the favorite way how our deputies do this, in order to destroy something of value, something good that may bring a real value to building up our society. And before these amendments, before this draft law, it is not into effect yet, and these norms that protect whistleblowers, I believe they should include, they will be stronger without these amendments. And we have small number of successful cases when whistleblowers, when he provides this information, when he implements his right to do this, he cannot then be a part of the collective, of the society, of organization, because we have distorted view who these whistleblowers are, and distorted view what value they have. And from experience of foreign countries, we know that whistleblowers, this is the powerful instrument to prevent corruption. And this creates societal control. And if there is lack of control, then there will be chaos. And these anonymous channels of communication, I have been working for 6 years. We built anti-corruption compliance at Energoatom enterprise. This is a very big enterprise. And we had internal channels, and 99% of all messages were through anonymous channels by anonymous whistleblowers. They used anonymous channels of communication, and they couldn't be identified. And Oleksandr mentioned the amendments, and this amendment, they create collision, and any collision in these relations, they interpret it to the benefit of those who commit corruption crimes. So those people who try to tell the truth, for example, the author of this law and other deputies, they said that these amendments will improve this draft law, and the protection will increase because there are mechanisms for reimbursement for this uncovering of such violations. There are 3 amendments that were voiced in the hall. They annihilate and nullify the essence of this draft law. And from my experience, I would like to say that even without these amendments, they could adopt the law, and it would be able to provide good protection. We need more legislation, one more law on this that would provide rigid punishment against people who abuse whistleblowers. And there is an article 172, but it is not, it doesn't work properly, does not provide proper qualification of the crime. And Vladimir Alexandrovich, I hope, won't sign this law because it fully contradicts his declarations, his slogans, and messages that he provided during his electoral campaign that he continues to declare. But the fact of this discussion and that this draft law adopted by the parliament, it does much harm to the institute of whistleblowing, because people are afraid, because they fear retaliation, and it is difficult to oppose the system, and people will fear more, because this is what may help to fight corruption, and the deputies, they show negative leadership in corruption prevention.
Thank you, Oleg. It's true that in public organizations of civil society organizations joined your position actually and shared this negative impression from the draft law. And besides that, the whistleblowing international network joined this negative opinion, and some foreign MPs. We have Ms. Anna Myers, Executive Director of Whistleblowing International Network, with us. Ms. Myers, why you suggest to veto this bill together with other NGOs? And could you please explain more about the role of whistleblowers at the international level everywhere in the world and the problems they face?
Good morning or good afternoon for you. Can you hear me okay?
Yes.
Perfect. My name is Anna Myers, and I'm the Executive Director of the Whistleblowing International Network, which brings together non-governmental organizations around the world who have been defending and working with whistleblowers, some of us for over 40 years, me for 20, and have been watching this space, understanding how the law and institutions and culture can affect whistleblowing. Whistleblowing is the act of responsible citizens who care about their work, their society, and the impact of wrongdoing on their communities. Most people who blow the whistle don't think about them as themselves as whistleblowers. They've come across wrongdoing and they have found themselves in a dilemma. And the dilemma arises when the people who they would normally report to, they are concerned that the message will not be welcome, or they are concerned that those who they would normally report to are involved in some way. So we have been seeing that whistleblowing laws have been changing dramatically over the last 15, 20 years. The Council of Europe, of which Ukraine is a proud member, has been working on this issue for a long time and has come up with a recommendation, which is still a very good basis for whistleblowing. And these changes that have been made in this draft law veer in the exact opposite direction, and they are veering into very dangerous territory, which is why we were very, very happy to support the civil society organizations, TI Ukraine, ACREC, and others in the Ukraine who are raising the alarm. Whistleblowing laws are about protecting the ability of people to speak up when they see something going wrong. They are meant to actually allow and encourage the free flow of information for the responsible exercise of authority. So whistleblower laws are not meant to be about telling people what to do, when to do, and placing very high barriers on them. We've already seen that the barriers are there. There are plenty of barriers that stop people from speaking up already, and those could be issues around very strict hierarchies. They can be issues, as I said earlier, about concerns about who is involved with the wrongdoing. So if one thinks about whistleblowing as a free flow of water in a river, there are plenty of stones that can get in the way, and we're trying with our whistleblower laws and institutional systems to remove those stones or allow the free flow to continue. These amendments that are proposing to shift the responsibility away from those who are meant to be accountable for wrongdoing onto those who are the messenger are deliberate and will create further difficulties for people to speak up. For many reasons, I think that this should be something that people very much get on board with. If you start to restrict how people speak up, and what these amendments do is they're saying that you have to prove the wrongdoing. There is no law enforcement agency in the world that says to a witness to a crime, before you report the robbery that you think may have happened at your neighbor's, you need to go and investigate it first and know that it is happening and then come to us. What this law says is you have to be so sure before you come forward that in fact it's not worth coming forward because the onus will be on you. And if you are concerned, if you've seen the broken window and you've seen the brick outside that window and you know your neighbors are away, normally as a good citizen you would want to speak up and help your neighbors. But if you know that you are the one that will be put on trial, not the wrongdoing and not the information tested, then you will not speak up for your community. We also know that without active civil society engagement, defending whistleblowers, monitoring the laws and institutional systems that are meant to support them, whistleblower protection laws can very quickly deteriorate into information control systems for those in power who do not want to be held to account for their actions, those in power who may prefer the status quo, those who do not want to be challenged or embarrassed by information that could reveal their own negligence, and who therefore want to be in control of the information and who is allowed to disclose it and when. It was mentioned earlier, I think, in what you were saying, that some concerns about anonymous reporting can very easily fit into histories where there were information control systems, and they were about reporting only to one place, to do so anonymously, and therefore the only people who controlled that information were the state, who could then use it against their own citizens. Anonymity in strong and active whistleblowing laws are not about using that information against others. It's about trust, and it's about ensuring that people can have an ability to have their identity hidden until they are sure about what is going to happen with the information, and unless they see that they can make a difference. So we have seen a real evolution in systems that allow for two-way discussions, and when people do see that it will make a difference, they do want to be part of the solution, and very often they have no difficulty in revealing their identities, which has always been a little bit of a surprise. But really, the biggest reason that people do not speak up is not just because they feel that they will be retaliated against, but they can feel that it will make no difference. So really, whistleblowing laws and whistleblowing systems are to encourage people to feel confident to speak up. The more that that happens, the less we will need these systems that are about anonymous reporting. The more you have a culture of openness and ability to be accountable, it will work in favor of good citizenship and protecting society. So you can see so instantly how something that is favorable for society and for whistleblowers can be flipped and start to work against them. So when we saw that these amendments were happening, and we saw that the Ukrainian civil society picked up on them quite rightly, we were delighted to join in. We had over 40 organizations sign on to the letter of support that we wrote in a record time. It was like 2-day turnaround. And so that was quite a good response. We would have had more if we'd given them more time. But I'd like to point out that among those who signed on were the European Centre for Press and Media Freedom, Euromil, which is a union for military organizations, a European organization, as well as the European Public Service Union. So this is an important issue for unions as well. So I'm very happy to answer any questions that you may have for us, but I just wanted to thank you for the work you're doing in the Ukraine. It has such a good foundation of whistleblowing law and practice that is worth following, but these amendments will take it in the absolute opposite direction.
Дякую дуже, пані Анно.
Thank you so much, Ms. Myers, for your brilliant intervention. I would like to mention the names of countries whose representatives from the Whistleblowing International Network had signed the appeal. This was Ireland, US, Canada, Australia, Czech Republic, Norway, the Netherlands, Switzerland, Denmark, Slovakia, and many, many others. All those representatives from many countries had signed open letter appealing to the president to veto the proposed bill. The whistleblowers and NGOs of whistleblowers are not indifferent, not only here in Ukraine, who encouraged the president to veto this bill, and we are very grateful to the Whistleblowing International Network for their support. And now I'm happy to give the floor to Mr. Tom Devine, legal advisor to the Government Accountability Project. I would kindly request Mr. Devine to explain how the perfect whistleblower protective scheme should work, how whistleblowers should be protected by the state, and how preventive measures against disclosure of whistleblowers should be taken by the state. The floor is yours, Mr. Devine. It looks like Mr. Devine is connected, but we have to wait for a couple of moments. Mr. Devine is also a member of the Whistleblowing International Network in the United States, and it also, this NGO also protects whistleblowers. We are very happy that Tom today is with us. By the way, in that letter which I mentioned earlier, which was signed by the NGOs from many countries, there was also a quotation from Mr. Devine, and this shows how much importance is given to this law, this draft law at the international level. Okay, now my question to Ms. Myers. Could you please describe how that letter, open letter, which we mentioned, was prepared and drafted and prepared and circulated? Because I saw that Transparency International as signatures from Transparency International in Estonia, etc. Could you please tell us how you analyzed the amendments and how you managed to actually disseminate this information among such a big number of signatories? Thank you.
Happy to, and I can see that Tom has joined us, so I'll just do this for a minute and then we can pass to him. Yes, WIN is, as I mentioned, an international network organization, and basically the core organizations are nonprofit bodies that have been giving legal advice to whistleblowers over many years. And as you mentioned, the Government Accountability Project, Tom Devine is legal director of that in Washington, D.C., and it's been operating since the 1970s. We were able to put that letter together partly because Tom has been working a lot in the Ukraine and was following those issues there and knew exactly what the problems were and has that legal analysis. But we've also been working together on the EU directive, which is now the EU directive on the protection of reporting persons, which 27 member states have to turn into national laws by December of this year. And we were involved in advocacy leading up to that. I personally was involved and was advisor to the Committee of Ministers that developed the recommendation on the protection of whistleblowers at the Council of Europe, and that still is a very strong basis for whistleblowing laws. So our networks have been operating from 40 years on, but in Europe over the last 20 years. So when we do put a letter together like this, which came from our board, who are all legal experts, and then in national organizations, and have been dealing with whistleblower laws and similar attacks on their laws over the years, and so we're very able to put that together very quickly against both the EU directive and the recommendation on the whistleblowers from the Council of Europe and international best practices. We want to continue to push and progress this further. This is about, as I said, the free flow of information for the responsible exercise of authority. We are being governed in different ways around the world, but yet whistleblowing is something that is natural around the world. It's a human activity. You can see it in religious texts, the Good Samaritan, people speaking up. We need to make that easier, and we need to then take the message and sustainably change things so that we don't need to continue to blow the whistle. So I'd be very happy to come back and answer questions, but I think you would like now to move to Tom about what perfect laws exist out there or what the ideals should be.
Дякую дуже, пані Анно, за відповідь на питання і дякую дуже за всі ваші зусилля.
Thank you, Anna, for your response to this question. Thank you for your effort in protecting whistleblowers.
Я дуже радий вас вітати.
We have Mr. Tom Devine connected now, and my question to you, Mr. Devine, how do you think the ideal procedure for protection of whistleblowers should operate without such amendments which are proposed now? The floor is yours, Mr. Devine.
Tom, just unmute.
Thank you very much for honoring me by attending this morning, and thank you very much for your defense of freedom of speech. To answer your question, I think the answer would be the whistleblower protection law that Ukraine passed in December 2019. Government Accountability Project, where I work, just finished a study of international laws globally. And if the whistleblower rights in the anti-corruption law had been in a general, broad whistleblower law, it would have been the finest whistleblower law in the world. We thought that conceptually it was a real breakthrough for freedom of speech. Unfortunately, with these amendments, if President Zelensky signs them, with these amendments, we would have to warn people against trying to defend their rights under this law, because the law would transform from a shield into a trap that not only guarantees whistleblowers will engage in professional suicide by fighting corruption, but that they'll take down everyone who helps them. Why do I say that? The law still would have strong rights for public freedom of expression and for speaking with government authorities. Well, 96% of whistleblowers make their disclosures internally. They don't break ranks. They're trying to solve problems within the organization where they work. And that becomes the Achilles heel of Ukraine's law, because you're turning yourself into a martyr if you operate within the organization where you're employed. Number one, there's only one person in that organization that you can talk to, the head of the unit. There's no even technical, theoretical channels that are available to you except with one person. And secondly, you have to have conclusive knowledge of the wrongdoing that you're challenging, or else you might as well be turning yourself in for reprisal. You don't have any rights that are meaningful. Well, conclusive knowledge, that's more evidence just to be eligible for protection than it is to put someone in jail for engaging in the corruption. Third, you have to have conclusive knowledge that the person you're talking to is innocent. Well, a whistleblower is just a witness. You have to have more evidence of that person's innocence than a court would have at the end of a trial or a prosecutor would have. And finally, you have to turn in all of your sources of information. And that means exposing or outing the people who helped you. And that will lock in isolation for whistleblowers, which means that they're not going to be able to get the supporting evidence they need to prove that conclusive knowledge of corruption, a complete trap. These are four cornerstones, not only for failure, but to turn a protection law into an attack on whistleblowers. Whistleblowers, you know, they're the servants of the people in real life, and they need President Zelensky's support when it counts.
Дякую дуже, пане Томе. Дійсно, викривачі – це...
Thank you, Mr. Devine. Actually, we see that whistleblowers are actually the guardians of public interest in society, and this is extremely important to provide them with secure conditions. How do you think, Mr. Devine, whether that ideal level, so to say, of the whistleblowers' protection will be sufficient for Ukraine? Whether it is possible to reach this sufficient level of protection for whistleblowers with existent legislation, and whether for Ukraine it's possible in general? Thank you.
Well, absolutely. More can be done, even than the 2019 law. And the current legislation had some effective improvements. They're still there behind the poison pills. For example, having a unified portal so that there's one coherent outlet for whistleblowers to attend. That's very helpful. I was impressed that the new legislation allowed whistleblowers to go to any government authority that has law enforcement responsibilities, and not just the NAPC. It's too much to funnel everyone into one spot. The law could use further improvements, such as refining the burdens of proof to match the new European Union directive, to have mandatory training. For example, a USAID contractor is doing training of judges in the Ukraine. Well, that should be mandatory. It should be a requirement that judges are certified that they're knowledgeable in the law before they issue decisions. No one gets it completely right the first time, but Ukraine got it more right than any other country that I've studied the first time. And you're on the verge of being more wrong than any other country in the world. There's no other nation that requires conclusive knowledge. No other nation requires you to expose your sources. No other nation only gives you one person where you work that you have legal rights if you speak with. This would be a horrible mistake, turning a major reform into a global embarrassment.
Дякую дуже, пане Томе. Дійсно, оцей портал.
Thank you, Mr. Devine. I believe that the portal, which is to be introduced by the law 3450, that's perhaps a good thing, but this should not be done on the account of the damaging amendments which go together with this positive establishment of the portal. Now, I am pleased to give the floor to Mr. Andrei Beletsky, Administrative Director of ACREC. My question to you, how do you think what amendments or improvements should be introduced in Ukraine to guarantee sufficient protection to whistleblowers in Ukraine? Thank you for invitation, and thank you to our international partners who joined us. Of course, whistleblowers is an important tool for disclosure of corruption and other abuse of power made by people taking high positions, and there was a much effort contributed into establishment and development of such a tool in Ukraine. And fortunately, in 2019, we have reached a good balance between the NAZK and the civil society organizations ready to do that. That single portal for whistleblowers was a good tool. In the law 3450 was quite good. It was drafted with involvement of representatives of monomajority in the parliament, and before the second reading, the bill was almost perfect. But unfortunately, in the parliament, in course of voting for some amendments, representatives from Batkivshchina faction suggested some, so to say, minor oral amendments, but those amendments changed the essence of the law considerably. By the way, the Batkivshchina faction did not vote for the bill in general, but they manipulated with the plenary room when voting for those three very harmful amendments. So now we have amendments that people have to prove their sources of information information. The whistleblowers thus will need to spend more on legal advice, and even now free legal aid is insufficient for proper defense of whistleblowers when it achieves the court, when the case achieves courts, but with these amendments, the situation will be very bad. That's why we are very grateful to our partners who encouraged the president to veto this version of the law. Actually, the vetoing of this law and sending it back to the Verkhovna Rada is not that bad as one could imagine. Actually, according to legislation, after vetoing, MPs will have 30 days to review the law in line with the simplified procedure. They have to review the amendments which prevent the law from being signed by the president, or they have to overcome the presidential veto with a huge number of votes. We believe that the first scenario will be easily implemented because the majority in the parliament would realize that they were manipulated by one faction, and they will correct the situation. And thus we encourage once again the president to veto the draft law because of that three crucial amendments which were introduced to the bill at the final stage of voting in the second reading. Thank you, Andriy, for all your proactive work and for your active position and your efforts to contribute to the possibility for people to report improper behavior. Now, I think it's a good time to open our Q&A session. Please, if you have any questions, raise your hands and introduce yourselves. There are no questions, actually, so the final remarks. It's not so easy to be a whistleblower in Ukraine. This is a rather tough topic, and unfortunately the lawmakers had even complicated, even more complicated this thing. So our objective now is to do everything possible that those negative amendments which were suggested by legislators would not be passed at the presidential level, and that the law should go back to the parliament for final review. We are very grateful to our international partners who joined us today, who supported this move, and we are also very grateful to those Ukrainian organizations who had signed this letter to the president. Thank you.